Welcome back. Today's video hits hard as four self-styled sovereign citizens run straight into four no-nonsense judges, including a familiar repeat offender who once again collides with reality, so strap in because this moves fast. Quick shout out to today's sponsor, Exter, a brand I've trusted for years because their smart wallets and travel gear actually deliver, with sleek design, RFID protection, and tracking features that keep everything secure and stress-free on the move. I appreciate their continued support. Check the pinned link, explore the Extra lineup, and use code SKEPTIC for a discount. Now, let's head to Florida and jump right into the first case.
State your name, sir.
Mr. Fox, for the court charge of possession of paraphernalia and a no valid driver's license. You understand the charges?
You understand what you're charged with?
No? No. She doesn't understand. Allegedly, you had methamphetamine on or about your person, and allegedly, it may have been contained within something that qualifies, aka a clear plastic bag, that qualifies as paraphernalia in the state of Florida. And allegedly, you were operating a motor vehicle without allegedly having a driver's license. You understand that?
I understand the driver's license, yes, sir.
Okay, well,
Possession.
I didn't say it was yours. Did I say it was yours? I said you've been charged with.
Right.
Nobody's asking if you did it. I'm just asking if you understand what the charge is. Yes or no?
No, sir.
Okay, then we'll bring you back tomorrow when you understand.
I was hoping I'm not from this state. This county. If I can just resolve everything today.
You got a parole hold. You wouldn't get out anyway.
You got nowhere to go, man. So, do you understand the charges against you or not?
I understand they charging me with it, yes, sir.
That's all you got. See how easy that is? I don't know why do we have to go back and forth
It's
about
not
it?
easy when you're in my shoes, sir.
It's easy it's a yes or no question. Do you understand?
I don't agree to the
Nobody's
contract.
asking you to admit to anything. I just need to make sure you understand the charge.
I'm a private citizen, sir.
I'm shocked.
Under UCC focus.
Oh, UCC? Oh, I love it. A sovereign. Golly Moses, I love those.
I genuinely enjoy watching this judge because he stands out as one of the most entertaining, sharp-minded, and intellectually engaging judges I've had the opportunity to cover, consistently offering lightning-fast wit, thoughtful analysis, and insightful commentary that not only elevates each courtroom exchange but also makes every moment feel compelling, dynamic, and genuinely memorable.
Mr. Fox, crap in one hand, hope in the other, and see if that helps. Bond set at 5,000 on the meth, 1,000 on paraphernalia, 500 on the driver's license, which oddly enough, the Supreme Court said you do need to drive. Court date is February the 17th at 9 o'clock, but you're not going anywhere because you got that probate or that parole.
Step to your right to the T.
Mr. Fox, when you sue me, make sure you spell it with two N's. I want to make sure that the AG's office gets involved.
You don't have to worry about that, sir. I'm peaceful.
Sign where the light is for your copy of that. Next.
That was a solid and engaging way to kick things off after the holidays, and I hope you had a Merry Christmas along with a strong and positive start to the new year, because next, we head to Bothell, where we come across an individual motivated far more by misguided beliefs than any real legal understanding, someone who loudly refuses to cooperate with the law while simultaneously displaying a confident yet deeply flawed grasp of how it actually works, ultimately setting the stage for yet another completely unnecessary and entirely avoidable courtroom confrontation.
It's off the 11 o'clock calendar. Mr. Calzada, could you please turn on your video for me?
Yeah, hold on one second.
All right. Good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with the case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you
Here
please
I
tell me?
am.
Well,
I'm here
please tell me,
physically present, right?
Mr. Calzada, could you please, what is your first name?
My first name? Well,
Mhm.
it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Lohr, you'll have law enforcement standing by. All right?
Well, there you are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment.
And yet, despite all of that resistance and defiance, you're still legally obligated to show up. Funny how reality has a way of asserting itself no matter how loudly it's denied, isn't it? And maybe it's just me, but the tone and delivery feel strangely familiar, almost cartoonish in nature, like an exaggerated character voice that completely undercuts any attempt at authority or credibility, transforming what should be a serious and consequential moment into an unintentionally absurd and almost theatrical display.
And you guys were all doing Snohomish County prisoners. Pretty busy, huh? The sheriff even said it's pretty busy. The court has to file a 1099-C. How you
All right.
file a 1099-C for that bond? You don't need voter approval for that, don't you, those bonds? How much are the bonds? Who
Mr.
issued them?
Calzada, I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time, all right?
Looks like there's no free will then.
So,
So then what am I doing here then? Hold on, what am I doing here?
well, right now you are not responding to my questions. So
Well,
I'm
you're not
going to have you
responding to any I don't have a problem of answering any of your questions, but I have a couple questions first. I have to understand too. I don't understand what's going on. I don't know everything.
Yeah, no one here is perfect. None of us are. But this isn't about knowing everything or having all the answers. It's about the complete absence of genuine understanding, a kind of misplaced confidence built on nothing solid at all, where certainty is loud, conviction is bold, yet substance is entirely missing, making the widening gap between personal belief and actual reality impossible to ignore.
come in person so that we can be sure that you understand what's
All
going on.
right, great. I'm glad. It's definitely implied, isn't it? It's not expressed. It's implied.
December 31st at 1:30 in person.
December 31st at 1:30, I'll be there.
Very good. We'll see you then.
All right, that wraps up that video. I stuck around on the 31st waiting to see his next scheduled appearance, but either he didn't show up at all, or it simply never made it online. And since Bothell usually uploads the majority of their hearings, there's a strong chance he skipped it altogether, which means the system will catch up to him sooner rather than later, and he'll inevitably be back in front of the court. With that behind us, we now move over to Judge Slavin's courtroom, where a familiar repeat offender once again takes center stage, a well-known figure whose ongoing pattern of poor decisions and repeated missteps has turned him into a recurring illustration of exactly how not to approach, respect, or navigate the legal process.
Ms. Sobe, you're here on the Martin matter, correct?
Yes, Judge.
Let's go have a conversation outside.
He'll be okay. So everyone tell me.
All right, today is the date and time set for a hearing in this matter with regard to a bond violation. This is case 242448 SM. People versus Eric Martin. Everybody hear me?
Yes. Good morning, Judge. Donna Sobe on behalf of the people, P87439.
Morning, Your Honor. James Gazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I'm making a motion to withdraw. I've had contact with Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I can adequately represent him, Your Honor. So I'm asking to withdraw.
All right, your motion to withdraw is granted. Mr. Martin, Would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements you're talking about. There's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made at me, so.
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court, and I find him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything and you keep doing all your little negative comments, things that you want to say about people. And you think you're the smartest person in the room and that you have some sort of special Juris Doctorate, I guess, from somewhere. I don't know.
Oh, I'm sure he did, gaining his so-called legal expertise from some imaginary fairy tale institution, and you could tell from Judge Slavin's previous encounter with Eric Martin that his patience has completely worn thin, as the judge is clearly finished, entertaining baseless sovereign-style arguments and manufactured legal theories, fully prepared to impose real consequences, restore a sense of order and calm for everyone else involved, and allow the justice system to deal with Mr. Martin in a way that finally brings structure, accountability, and a long overdue sense of finality to the situation.
Clue when it comes to things, and you talk about that, and so Mr. Gazicki is saying that he's trying to talk to you about actual legal defenses, and you're trying to bring up some kind of other stuff. And so I'm going to grant his motion. Do you want, all I asked you was this. I didn't ask you to give me a commentary about Mr. Gazicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering the questions.
Yep, one another attorney, but I don't want to state also that if it was recorded, that we would say it would support my allegations.
Boom, time out. Nope, not hearing it. The question is this: do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. What is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you'd like, or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another appointed one, but without.
All right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. He did. Well, I won't say for the most part. Maybe for the most part, but there's some things he didn't do neither. He should have. He didn't raise my right to travel defense. So
yes or no? Yes or no? Is he somebody that you think you can get that you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint. Reach out and see if we can see if he's available. So let's appoint.
But now, Slayton, I have some questions for you before you move forward.
All right. So we're going to set that. We're going to set that for a hearing date, and we'll see you then.
Hold on.
Bye. Have a great time.
I won't pretend to hide my frustration here. It's not about labels, movements, or buzzwords. It's about someone who repeatedly and deliberately refuses to accept that courts have both the authority and responsibility to protect people from harassment, and that kind of willful denial, repeated over and over, becomes genuinely exhausting to watch. Seeing firm boundaries finally enforced feels far less like punishment and much more like long overdue accountability finally catching up. To close things out, we stay in Michigan and step into Magistrate Heiss' courtroom, where yet another overly self-assured individual runs through the same recycled script with absolute confidence, only to be shut down cleanly, calmly, and decisively by facts, procedure, and the law itself. I came across this particular clip on Old Squishy Gardner's channel, which remains one of the most reliable and consistently solid sources for documenting courtroom absurdity. So if you're a fellow legal process enthusiast like me, it's definitely worth checking out and showing a bit of support.
Okay, good afternoon. My name is David Heiss. I'm an attorney magistrate. We are scheduled for an informal hearing in two different cases that arise out of one citation. And those
Correct.
two cases are both entitled The People of the City of Battle Creek versus Roosevelt LaShawn Williams. Is that your name, sir?
That is my name.
Basically, what happens is you were issued one citation. It had two violations listed on it. So it became two different cases, one with an A and one with a B at the end. But we have one informal hearing scheduled for both of those cases because they both arise out of the same transaction, so to speak. And I guess, Officer Kellums, is there anything before I begin?
No, sir.
All right. Mr. Williams, you're here because you were issued a citation. And in each of those two cases, so for each of those violations, you have three possible responses to the citation. You can first admit responsibility, be assessed the fines and costs, and be done with it. You could, as a second option, admit responsibility with an explanation, hoping that the explanation would cause the court to decrease the fines and costs a little bit. Or you can deny responsibility and have your hearing. It's my understanding that as to both cases, you wished to deny responsibility. Is that correct?
That is correct.
Okay. Well, here's how the hearing works. First of all, I guess I should read the citation. In the case ending with the letter A, it's alleged that back on November 19th of 2024, you were over at Fountain Street near Meacham Avenue in the city of Battle Creek, and you were issued a citation for not being able to provide a proof of insurance. This is a civil infraction. If you were found responsible, all other things being equal, the court would assess $125 fines, costs, and fees. It is a 0-point ticket. And in the second case that ends with the letter B, that same date, time, and place, you were issued a citation for having an expired registration plate. That is also a civil infraction. It is also a 0-point civil infraction. If you were found responsible, all other things being equal, the court would assess $110 fines, costs, and fees. So first question, is that the ticket or the two cases that you thought you were appearing about, Mr. Williams?
It is.
Okay. And same question to you, Officer Kellums?
Yes, sir.
Very good. In every civil case, the plaintiff has the burden of proof. And in a case like this, that burden of proof is called by a preponderance of evidence.
Only question I have is, will the laws of the U.S. Supreme Court be applicable? And the federal statutes and definitions of motor vehicle and automobile be applicable in this proceeding?
They are the state of Michigan laws that will be applicable.
Okay. The other question is, are you already not bound by U.S. Supreme Court rulings?
Every court is bound by relevant Supreme Court rulings.
Okay. All
I'm
right.
not quite sure.
He's asking that question because he believes it's some kind of strategic win to force an admission that judges are bound by Supreme Court precedent, but that supposed victory exists only in his imagination because it's not revelatory or controversial at all. It's completely routine and universally understood. That line of thinking is about as impressive as asking a math professor whether addition and subtraction will appear on an exam, proudly mistaking fundamental baseline rules for a clever gotcha, when in reality, they're just the basic framework everyone already knows, accepts, and operates within every single day.
All right. So if you would both raise your right hands. Very good. All right. Officer Kellums, if you would begin, please.
So on November 19th, 2024, I was on patrol for the Battle Creek Police Department when I observed the vehicle that Mr. Roosevelt was driving. I observed that it had expired tags on the vehicle. I then conducted a traffic stop on Fountain Street near Meacham Ave. Found Mr. Williams to be driving the vehicle where I issued him the citations. When speaking with Mr. Williams, he could not provide insurance and his tags were expired.
Okay. Do you happen to know when they expired?
I do not off the top of my head, sir.
Okay. What made you think they were expired? The wrong color and the wrong year on the plate itself, or some other
Yes,
thing?
sir. Yes, sir.
All right. Did Mr. Williams say anything to you during the stop about having insurance or not having insurance, or anything about the tags on the plates, anything like that?
He informed me that he did not have to have insurance due to he was traveling, and to drive a vehicle, you have to have insurance. Something regarding Supreme Court. That's about all he said.
Okay. All right. Do you want me to consider anything else at this point, Officer Kellums?
No, sir.
Okay, Mr. Williams, could you hear Officer Kellums' testimony?
Yes, I heard his testimony.
Very good. Thank you for your patience. What do I need to know, sir?
Okay, I did inform Officer Kelly that I am not operating a motor vehicle, but I am operating an automobile. I did inform Officer Kelly of the ruling of Rodriguez v. Ray Donovan, U.S. Department of Labor, 769 Federal 2nd, 1344, where the U.S. Supreme Court's decision has ruled that all codes, rules, and regulations are for government authorities only and not for human creators. In accordance with God laws, all codes, rules, and regulations are unconstitutional and lacking due process.
All right, I'm going to interrupt you just for a second. Are you telling me that a case at 769 Fed 2nd, 1344 indicates that all laws are unconstitutional?
All codes, rules, and regulations. Yes, sir. Rodriguez v. Ray Donovan. And if I'm not mistaken.
And you said that was Department of what?
U.S. Department of Labor.
Okay. U.S. Department of Labor doesn't publish decisions in the Fed 2nd. Can you tell me a little bit more about the case? What was that issue in the case?
It was regarding what we're discussing here, the requirements of a driver's license and the need when it's required to have one, stating that when you're not operating in commerce, to which I informed the officer that I am not operating in commerce as stated in USC 18 USCA 31 paragraph A6 states that a motor vehicle, the term of motor vehicle meaning every description of carriage, conveyance, propelled or drawn or mechanical powered and used for commercial purposes. This is what Title 18 USCA Section 31A6 states or defines as a motor vehicle, to which I am not operating in commerce.
This issue comes up often, and since I haven't clearly broken it down before, here's a concise and accurate explanation. Yes, 18 U.S.C. Section 31 defines a motor vehicle as one used in commerce, but that definition applies only within that specific chapter, as stated plainly in its opening line. When you actually review the chapter, only 2 sections even reference motor vehicle, while a few others mention vehicle in entirely different contexts, one of which clearly refers to space vehicles, which obviously has nothing to do with cars on public roads. As for the case, he cited Rodriguez v. Donovan. It's a puzzling choice, because it dealt with IRS benefit issues and a jurisdictional dispute where the Supreme Court compelled a district court to hear a case it had initially declined, not a ruling that invalidated laws or supported the claims being made. In short, the argument sounds confident but collapses completely under even basic legal scrutiny.
I'm not using...
For the purposes of that particular chapter of the United States Code, it would not control what happens in terms of the Michigan legislature defining in Chapter 257 what a motor vehicle is, and an automobile under Michigan law is a motor vehicle. But okay, continue.
It's a motor vehicle, which is described as anything, even by the Michigan compliance statute of 751, which you just stated, is determined as something that's transporting goods, which I'm not transporting goods.
I understand your position, and I can tell you that position doesn't happen to be legally correct. But go ahead.
So you're basically stating that there's a misinterpretation of what's in black and white?
No, I'm telling you that you have misinterpreted the application of 18 USC 31A6 and 769 F second or Fed second 1344.
Okay,
But
well, I see where
I've
this
heard
is
your
going.
arguments.
So there will be no further arguments because I see that you're not going to agree to. Because, like I said, I've given it to you the cases where they're like Shapiro v. Thompson, where the U.S. Supreme Court has said that this a driver license is not a requirement. That this is you're trying to convert a right into a privilege, to which is covered by Article 1, Section
All right,
8,
well,
to which
I'll ask you this: is that right? The right to travel?
that is a right to travel, convey, however you want it, by
Well,
the U.S. Constitution.
what you just told me was that somehow but regardless, am trying to convert a right into a privilege. Now, the question I have for you is, what right has been converted to a privilege?
My right to freely travel
Okay, very
unencumbered
good.
and
Now,
unfettered.
I will ask you this: how is your right to travel removed by receiving the citation?
By trying to require me to have a license to operate a automobile, which is my private vehicle.
Okay. All right. Is there anything else you want me to consider?
No, sir.
If that truly represents the full scope of your argument, then the conclusion is straightforward and unavoidable. You're guilty. And it's important to clarify that the phrase right to travel does not appear verbatim anywhere in the Constitution. Rather, it is one of several unenumerated rights that are nonetheless firmly recognized and protected within our constitutional framework. The Supreme Court has repeatedly affirmed this principle through long-standing and well-established precedent, including landmark decisions such as Shapiro v. Thompson, which clearly confirms that the freedom of citizens to move freely between states is a fundamental component of our constitutional system, not some hidden loophole, not a clever defense tactic, and certainly not a shield against lawful responsibility or accountability.
The Michigan motor vehicle laws, including the laws that require you to carry insurance, that require your vehicle to be registered, and require that registration to be current, do not run in violation of any right to travel under the Constitution or the United States Supreme Court decision that you have cited. In fact, Michigan courts have held that essentially the right to travel means the right for you to move from A to B, not the right for you to travel from A to B under your most convenient way. So you could walk from point A to B all you wanted. You could take a taxi or an Uber or a plane or a train or a bus. But if you wish to travel by using a motor vehicle, the Michigan laws are applicable and don't unconstitutionally interfere with the right to travel. It doesn't convert the right to travel into a privilege. You are not denied the right to travel. You may be denied the privilege of traveling via a motor vehicle that you are operating. So,
okay, so
that is what the law says, and that's what I'm finding. Is there anything else you want me to consider about that finding?
Shuttleworth v. Birmingham, U.S. 147. Do you mind telling me what the U.S. Supreme Court ruled in that?
U.S. 147 doesn't give me the site of a case. That's an incomplete site of a case. Okay.
It was Shuttle.
And if you wish me to consider the case, why don't you tell me what was at issue in the case and what year it was decided?
I said Shuttleworth v. Birmingham, U.S. 147, 1969, where it says
U.S. 147 is not a complete cite. The way you cite to a case is by name and then volume number and then the name of the publication and then the page number. So, for instance, when you said 769 Fed 2nd 1344, what that means is volume 769 of a book or volumes called the Federal Reporter, 2nd edition, at page 1344. So when you're asking me about this most recent case that you've talked about, what you said was US 147, I think. That's not the citation to a case. So you're going to have to tell me more about that case. Who were the parties to that case? and what issue was before the Supreme Court in that case.
Okay, so you didn't hear me cite the name of Shuttleworth v. Birmingham?
I heard you say the name. That
Okay,
doesn't tell me
and
what, that's not a complete cite of the case.
all right. Do you not have the documents that I filed when I filed to say that I want to have an informal hearing? The affidavit that writes that my
There are documents that have been scanned into the court that you dropped off.
okay.
So
So
from
even
those
if
documents, why don't you tell me the proper citation for Shuttle versus Birmingham?
Come on, magistrate, expecting him to properly cite a Supreme Court case is a pretty tall order when he can't even grasp the basic fundamentals of what those rulings actually say or mean. And that gap in understanding shows immediately. That said, it's still worth clearing up a very common misconception, because sovereign-style arguments frequently and confidently misuse Shuttlesworth v. Birmingham, even though that case dealt squarely with civil rights violations and freedom of assembly, not any constitutional right to travel, making it entirely irrelevant in this context. This recurring pattern of misapplication highlights a much broader problem invoking case law with confidence, but without comprehension doesn't strengthen an argument or add credibility. It exposes its weaknesses, underscores the lack of legal literacy behind it, and ultimately reinforces why factual precision, context, and actual understanding of the law truly matter.